Yeah. Please. We have 123 sections in the bill.
Yeah.
We have 30 sections already with amendments here. If we keep going this way, we'll be until Christmas.
I understand. So it's just a key point.
Out,
and just in order to have a complete regulatory impact assessment, there will be outside interested parties who will want to make informed submissions to you on foot of these amendments, and they will have to be afforded an opportunity to do that as well. And squeezing it into a couple of days before we next sit at committee, I think is something which needs to be looked at.
Okay. Deputy Doctor, briefly.
With respect, Chairman, the difficulty here, Minister, is that it's now been 18 months since second stage, and now what we have today is a symbolic gathering for an hour and a half before the summer recess. We'll revisit all of this in the summer. We will probably get to parts 1 and 2 today. I can't see us getting to parts 4. And the difficulty is this. We're being asked to agree on sections which have a cost implication in terms of the professions. And there will be fees applied. We do know that can have an impact on people who are starting in the profession. And we sort of need to have the full picture. And that's the difficulty right now. We're being asked to sign up to the regulatory authority, give it the powers that's outlined, which will be to regulate directly, to deal with the considerable volume of complaints, take on board all of that, without having any real assessment of the costs of that and how those costs are applied to the profession. And there would be a concern that people, and we know that's across the legal profession, be it solicitors or barristers, people are struggling, particularly on the bottom rungs, to work their way up. So there has to be a concern about how this authority, which comes through in the first few parts of the bill, impacts then later down. Obviously, you have fees being dealt with later on in the bill. So, I appreciate that we all know about the delays in the AG's office. We know that many bills are being delayed in there, but this is a piecemeal approach, Minister, with respect, and we're being asked to subscribe. I'll wrap up with this. I'll wrap up with this. I promise to wrap up with the next 2 sentences. We're being asked to subscribe as legislators to a regulatory authority in the first few parts of the bill without knowing what amendments, what changes. You've indicated you're going to make changes, considerable further changes to this bill later down the line, but we don't know what they are. We don't have the full picture. So we've been asked to vote on a part of the picture without knowing the full implications of it. I don't think that's acceptable, Minister.
Okay, now I think the regulatory impact assessment is of concern, and we're only going to get to a couple of amendments this morning anyway, folks. So, and it will be September when we get back to this, and possibly even before the Dáil resumes. We can discuss that later. Minister, do you want to respond very briefly to those? Or can we move on? I'm very anxious that we've strayed away from the amendment quite considerably at this stage.
Well, what we're doing effectively today, if you look at the amendments we're dealing with, is dealing with the appointment of people to the Legal Services Regulatory Authority, the modalities of that, organisations who might make appointments. It's already a matter of principle in the bill that there is going to be an independent regulatory authority. Some of the issues the Deputy is raising are issues from much later sections of the bill, if as a matter of principle it's accepted by deputies that there should be an independent regulatory authority in respect of the legal professions. There's nothing that particularly hangs on what we're doing today that creates any unique new cost issues. It's about ensuring that there can be no question mark hanging over the independence of the body or the manner in which it operates. And that's essentially the amendments we're dealing with. And we will be dealing with other issues at a much later stage.
So listen, we're coming back to Amendment 2. And Amendment 4, and we've discussed both those amendments now. I think if we're satisfied with that, I can proceed. Okay. So Amendment 2, the question is that the amendment be made. Is that agreed? Agreed. Amendment 3, in the name of the Minister to move.
Yes, I so move, Chairman. This amendment is a technical amendment to ensure that the bills of costs referred to are any bills of cost issued in the past by solicitors or in the future by solicitors or barristers.
Okay, the question is if the amendment be made. Is that agreed?
Agreed.
Agreed. Amendment 4, already discussed with 2. Minister to move.
I move.
The question is that the amendment be made. Is that agreed?
Agreed.
Agreed. That section 2 as amended stand part of the bill. Is that agreed?
Agreed.
Section 3, amendment number 5, in the name of the Minister. Minister to move.
Yes, this amendment removes the current reference to the legal practitioner's disciplinary tribunal, as it's not desirable that the tribunal should have regulation-making power.
Okay, the question is that the amendment be made. Is that agreed? Agreed. That section 3 is amended stand part of the bill. Is that agreed?
Agreed.
Section 4. That section 4 stand part of the bill. Is that agreed?
Agreed.
Section 5. That section 5 stand part of the bill. Is that agreed?
Agreed.
Section 6. That section 6 stand part of the bill. Is that agreed?
Agreed.
Section 7, amendment number 6, in the name of the Minister. Minister to move.
Yes, again, Chairman, this is a technical drafting amendment which Parliamentary Council have deemed necessary for this particular provision.
The question is the amendment be made. Is that agreed?
Agreed.
That section 7 is amended stand part of the bill. Is that agreed? Section 8, in the name of Deputy McLaughlin, acceptance of this amendment involves the deletion of section 8 of the bill. This is a new section. 8 to 17 inclusive, alternative to 7, 10 is an alternative to 9, 12 is an alternative to 11, 14 to 17 inclusive, alternative to 13, 7 to 17 inclusive will be discussed together. Deputy McLaughlin to move amendment number 7.
Okay, I move, Chairman. In relation to this amendment, Minister, I do acknowledge that you have this amendment was obviously submitted on the basis of what was already on the table. I appreciate you have moved to deal with the concerns around the independence of the authority. I would ask you to go a little further. As you can see in my amendment, I'm asking for 13 members in the authority because I think it gives a broader scope. I'm not insisting on what I've presented there. I see that you have some different additions. I think this is something that we can all. There's obviously amendments similar to mine from Deputies McGrath, Deputy Collins, and indeed from yourself, Minister. So maybe this is something we could, talk about. But I do think you should push it out to 13. Just broaden the scope and the contribution to it. But I commend the fact that you have dealt with the issue of independence. You'll see also that I'm asking that the chairperson, doesn't necessarily have to be from the lay or legal backgrounds. The chairperson is the chairperson elected by the authority and the fellow members. And also in terms of the reports, that it is to the Oireachtas. What I'm trying to do is enshrine the independence, but I do appreciate, in fairness, you've dealt with those issues. I would only ask that you would consider pushing the numbers out to 13, and the make-up is up for discussion and agreement. Thanks, Minister.
Okay. Deputy McGrath, you want to speak to your amendment?
Just on Section 8, amendment. I just want to strongly endorse what Deputy Ford McLaughlin said in relation to the whole issue of 13 members. And I also want to use this opportunity as well of thanking and commending the Law Society of Ireland and the Bar Council of Ireland for their work in relation to these particular relevant issues. And I want to formally propose and support my own amendment.
Well, you can't until we get to it.
Yeah, sorry.
Yeah, we'll get to it in a second. Does anybody else want to? Now we're dealing now with all these amendments together. Okay, as far as 17. So if anybody wants to come into Deputy Collins, you want to come in?
Yeah, well, I have a similar amendment to Deputy McLaughlin's. I think we differ possibly on the numerical on the numbers between the different representative bodies, but we're still coming back to the net figure of 13. And I don't need to rehash the points made by Deputy McLaughlin, but I'll be moving my amendment, Chairman, when it comes.
Okay, Minister, do you want to come in on? We're dealing with all of those from 7.
We're discussing all of these amendments together.
7 to 17.
Yes. So if I could just start off by making reference to Government Amendment number 10 and the other amendments. Now, several of the following proposed amendments to Section 8 of the bill are intended to increase the actual and perceived independence of the authority from the government. When the bill was published in 2011, concerns were raised in relation to the issue of how the members of the new Legal Services Regulation Authority would be appointed and the independence of that process. These concerns emanated largely from the fact that the bill as published drew heavily from standard provisions relating to state bodies, whereas the Legal Services Regulatory Authority is a different type of entity. Immediately after publication of the bill, therefore, I made clear my intention to remove any unnecessary ministerial consents or involvements in the appointment or functioning of the new regulatory authority. This First Amendment makes it a requirement that an Oireachtas resolution be passed prior to the formal appointment of members of the authority taking place. Those members of the authority are now to be nominated by independent bodies, as we will see in my later amendments. The device of using Dáil and Seanad resolutions prior to the making of important appointments has other precedents on the statute book. For example, this is how the Garda Ombudsman Commission is appointed under Section 65 of the Garda Act 2005. It acts as one of a suite of safeguards being proposed in today's amendments by me against the albeit unlikely scenario of any given government of the day interfering with or arbitrarily interfering with the modalities of nomination and appointment to the new regulatory authority. Government Amendment number 11, the original provision of Section 8 subsection 3 reads that among those members to be appointed to the authority are persons who have expertise in relation to one or more of a range of matters, including the provision of legal services, the maintenance of standards and professions, regulated by a statutory body, and the needs of consumers of legal services. The proposed amendment to subsection 3 is a small but important one and is based on Advisory Council's opinion. The more specific criteria in relation to eligibility for membership, such that all members must have some of the qualities identified in Section 8 subsection 3 is required. The effect of the amendment is that not some but every member of the authority will have relevant expertise. This was always the intention, so it's a tidying up of that particular provision. Government Amendment number 13 amends subsection 4 of the bill. It belongs to a suite of amendments that are at the centre of what I would like to achieve here today, as they bolster with legal clarity the independence of the authority from government. The approach I wish to take has been influenced by written and verbal submissions from the Law Society, the Dublin Solicitors Bar Association, the Bar Council, several other key interested parties from whom we received submissions. It therefore meets most, if not all, of the concerns that lie behind the similar amendments being put forward by the opposition today, which closely resemble those proposed by the Bar Council. We are in agreement, therefore, that a separate nominations process of selecting members to the authority is desirable. Such a process will allow the new body to be sufficiently independent, while ensuring, under the criteria set out in the bill, the members have the required and relevant experience and expertise. Deputies will wish to note that, according to Section 8 subsection 3, members of the authority should have expertise in relation to one or more of the following matters: A, the provision of legal services; B, legal education and legal training; C, competition law and policy; D, the maintenance of standards and professions regulated by a statutory body; E, dealing with complaints against members of professions regulated by a statutory body; F, business and commercial matters; G, the needs of consumers of legal services. I kept these criteria in mind while selecting the nominating bodies. I believe are best suited to the task of finding the right people for the authority. There will still be only 11 members of the authority, 6 of whom will be lay persons and 5 of whom will be nominees of the legal professional bodies and their close affiliates. The bodies represent a balance between meeting the representative needs of legal professionals, the needs of consumers of legal services, and the needs of an authority which will have both a dedicated research as well as a regulatory function or remit.